Monet Bank is continuously recognized as amongst the safest and soundest banks across the globe and is well positioned for future challenges. Monet Bank is committed to its customer base's safety and soundness, but it also places additional focus on privacy, anti-money laundering, banking access, and most recently, consumer protection. Recently, the organization's first organizational risk assessment was conducted, which included a focus on cybersecurity. Additionally, Monet Bank applied for cybersecurity liability insurance as one way to address this risk but was denied. Monet Bank was informed the reason for application being denied was the Monet Bank's inability to demonstrate its regulatory compliance processes and strategies. Hi, I'm Leena Bongale, Chief Legal and Privacy Officer at Monet Bank Incorporated. Thank you for attending this session where I will walk you through how Monet Bank can build an effective cybersecurity law and regulatory compliance program. We will begin with getting a basic understanding of what is a cybercrime and what are cyber laws. Then we will understand what is a law versus a regulation versus a standard. Next, we will get an overview of the important cyber laws in the US as well as internationally. We will focus on how to design a cybersecurity legal program, and we will end with touching upon the concepts of what is computer forensics and understand why it is important for Monet Bank to get a cyber liability insurance and how it will help us demonstrate due care and due diligence. So we have a very packed agenda, so let's get on with it. Before we discuss how to build a legal compliance program, let us first understand what is a cybercrime and what are cyber laws. Cybercrime is any criminal activity that involves a computer, network device, or a network. Financial data is a desired target for cybercriminals. Hackers frequently attack financial institutions such as banks, credit unions, and brokerage firms. The US and many nations around the world have cyber laws that were put into place for their citizens to stay connected. This allows their internet users access, privacy, freedom of expression, and jurisdiction. Cyber laws are important because they incorporate all the activities concerning the internet. For efficient data security in the banking industry, Monet Bank needs to ensure proper compliance with banking cybersecurity standards, laws, and regulations, both at local and international levels. But the government and processes can be difficult to understand and navigate. The most common misunderstanding of governmental oversight is the understanding the difference between laws and regulations versus standards. Financial cybersecurity compliance is the adherence to laws and security regulations setting the minimum standard of data security within the financial industry. These regulations are either established by governments or authoritative security bodies, and their application impacts the entire financial services industry. Cybersecurity regulations must be malleable to remain relevant in a rapidly evolving threat landscape. This means Monet Bank must constantly keep track of changes to existing regulations as well as the establishment of new information security standards. This can be resolved by only focusing on complying to regulations that are mandatory for financial organizations and avoiding those that are optional. But the benefit of still implementing optional regulatory standards is that the addition of their security controls could further decrease cybersecurity risks. European Union, US has no single federal law regulating cybersecurity and privacy. 5 states, California, Colorado, Connecticut, Utah, and Virginia have enacted comprehensive consumer data privacy laws. The laws have several provisions in common, such as the right to access and delete personal information and to opt out of sale of personal information, among others. Other provisions require commercial websites or online services to post a privacy policy that describes the types of information collected, what information is shared with third party, and how consumers can request changes to certain information. Countries have shown that they care about protecting people's privacy, and there are among 120 countries that have international data privacy laws. Even though the nature of these data privacy laws can vary from place to place, most countries with ubiquitous internet access have some rules and regulations in place regarding what data can be protected and how it can be used. Recently, Europe passed a new law regarding how websites can collect and use people's data. Now when people use the internet in Europe, just about every website has a pop-up asking for permission to place cookies on the computer. There are some cookies that always must be active for the website to work. On the other hand, there are other cookies that cannot become active without the permission of the user. For example, functional cookies, targeting cookies, and third-party cookies are not allowed to be added to the website without the consent of the user. This makes it easier for users to control what data websites can use and what data the websites cannot use. GDPR was a breakthrough in data privacy, a true new golden standard among data protection regulations. Below are the most important principles GDPR introduced. Enabling data protection authorities, that is DPAs, to make binding decisions and issue administrative sanctions, including fines. The right to object to processing based on the controller's or public's interest. An obligation to notify DPAs and data subjects about data breach, stronger consent requirements, including biometric and/or genetic data in the definition of sensitive data. Introducing data protection officers or DPOs as a mandatory role in organizations that process personal data. But the GDPR leaves much to interpretation. It says that companies must provide a reasonable level of protection for personal data, but does not define what constitutes reasonable. This gives the GDPR governing body a lot of leeway when it comes to assessing fines for data breaches and non-compliance. After understanding what cybercrimes and laws are to prevent them and what regulations are in place at various geographic locations, now would be a good time to discuss how we at Monet Bank can establish an effective cybersecurity compliance plan so that we'll not only stay ahead of cyber criminals but also get a stamp of approval from government entities and avoid any fines or getting bad rep. The goal of a cybersecurity program is to comply with industry standards, regulatory requirements, security policies, and corporate interest. First and foremost, we want to be avoiding regulatory fines and penalties. Monet Bank should know its compliance obligations that pertain to financial industry. Violations of these rules are punishable by fines and other punishments. Next, we want to be protecting our company's reputation. A data breach will harm our company's brand and erode our customers' trust. Aside from the high cost and penalties involved with data breaches, Monet Bank must be transparent and inform its customers about the breach. As we look for solutions to protect against data breaches, having an efficient information security management tool is paramount to building loyalty and maintaining healthy relationships with our customers and stakeholders. And then we also want to improve our data management capabilities. Maintaining data security compliance for us begins with properly managing sensitive information about our customers. Monet Bank should consider upgrading its systems that simplify the application programming interface, that is the API integration process. A more streamlined automation system allows for seamless authentication and less lag time between updates, translating into increased operational efficiency and continued attention to privacy. Now let's look at ways we can make sure we are being compliant with cyber laws and regulations. Create a compliance team. Monet Bank must consider building a compliance team that will assess and monitor cybersecurity. The best method to assure compliance is to develop a strategy that brings the IT security and compliance teams together. Build a comprehensive compliance framework. A compliance framework and a cybersecurity framework provide a common language that allows individuals from all areas at Monet Bank to foster more secure and efficient business practices. A compliance and regulatory framework also provides a structured set of guidelines, standards, and best practices to help organizations achieve compliance with relevant laws and regulation. Monet Bank needs to adopt a compliance framework so we can understand which compliance requirements we must meet and how we can best meet them. Compliance management. Good compliance management assures that Monet Bank's policies and procedures conform to the financial industry's set of laws, regulations, rules, or standards. Compliance is critical for gaining our customers' trust, our business reputation, security, and data integrity, which all ultimately affect our bottom line. Promote team communication. Security compliance becomes more complicated when teams are siloed. At Monet Bank, the IT or the security team is on the front line of cybersecurity regarding breaches, attacks, and solutions to prevent them. They may, however, be unaware of the specifics of compliance and regulatory requirements. Likewise, the compliance staff may be familiar with the regulatory requirements but not familiar with the technology capabilities. Senior leadership at Monet Bank must promote teamwork and collaboration to assure the best possible solutions are implemented to protect our organization's best interests. Set up controls. As Monet Bank enables risk analysis, we must set up controls to maintain cybersecurity compliance. These controls may include firewalls, encryptions, password protection policies, vendor risk management program, employee training, insurance. Creating these can help reduce a hacker's chances of breaching our security. Automate controls. As Monet Bank expands its operations, it is impossible to keep track of regulatory and security compliance effectively with manual processes. Automation will allow us to focus on the big picture of streamlining daily chores, improving consistency, and ensuring regular monitoring and reporting. Perform consistent patch testing. Criminals are aware of patch release dates and anticipate that organizations will be late or miss their patching deadlines. Hence, Monet Bank must fix as quickly as feasible any critical faults and defects. Before putting patch systems back into production, we must make sure they are accepted. Connecting our tools. At Monet Bank, different management tools for each platform are standard in distributed environments. We can connect these tools via APIs. APIs will allow us to conduct activities on various devices using our favorite interfaces. Using fewer interfaces will enhance insight into all system security and compliance status in our environment and streamline operations. Creating policies. Policies are for documenting compliance activities and controls. They will serve as a foundation for conducting mandatory internal and external audits. To create one, we should identify what security measures our employees must always take and lay out a backup plan for emergencies. Training. Moned Bank needs to offer training for all employees. Training is done during the hiring process and when new procedures and rules are being implemented. Training will remind staff members and help them learn new ways of conducting their day-to-day job duties. Monitor and respond. Continuous cybersecurity is constantly evolving. In turn, cyber criminals are continually finding new ways to obtain sensitive information. Rather than finding new vulnerabilities known as zero-day attacks, they rework existing strategies. For instance, they can combine different ransomware programs to invent new ones. Moned Bank must be steps ahead of cyber threats. We must continuously monitor cyber threats and respond before hackers perform a data breach. Data can only be compromised if it can be read. Data encryption is a requirement by ISO IEC 27001, GLB, GDPR, PCI DSS, and other standards and regulations, as encryption is an efficient way to secure data, especially customer data. Encryption can be best described as a method of storing information in an unintelligible form that can only be accessed by the intended recipient. This method is utilized primarily to ensure confidentiality, promote integrity, and authenticate data. To protect our data in full, we must look for solutions that allow us to encrypt data both in storage and in transit. This way, we can significantly minimize the risk of a devastating data breach. As the Chief Privacy and Legal Officer at Moned Bank, it is my duty to warn and make recommendations to you, our senior leadership team, on the legal issues with encryption and cryptography. Encryption is a subject to a web of regulations around the world because nations view encryption as a dual-use technology that has military and commercial value. To varying degrees, they set restrictions on import, export, and their use. Other legal issues are patent-related and arise due to the complex mathematical nature of the algorithms involved. In some countries, even the domestic use of cryptography is or has been restricted. Until 1999, France significantly restricted the use of cryptography domestically, though it has relaxed many of these now. In China, a license is still required to use cryptography. Many countries have tight restrictions on the use of cryptography. Among the more restrictive are laws in Belarus, Kazakhstan, Mongolia, Pakistan, Russia, Singapore, Tunisia, and Vietnam. Some countries restrict the importation of encryption technology for fear of introduction of nation-state sponsored encryption backdoors. In law, spoliation of evidence is the intentional or negligent withholding, hiding, alteration, or destruction of evidence relevant to a legal proceeding. It is a criminal act in the United States under federal and most state laws. Spoliation has two consequences. First, the act is criminal by statute and may result in fines and incarceration for the parties who engaged in the spoliation. Secondly, case law has established that proceedings which might have been altered by the spoliation may be interpreted under a spoliation inference. For corporate America, this poses some serious problems. Monad Bank is not involved in litigation on a frequent basis, so when it occurs, discovery can be a strange process which leaves many managers doing their best to guess what information to secure and how to secure it. This is particularly true when it comes to electronic information. A court order to preserve electronic evidence may arrive that is very broad, leaving everyone guessing exactly what to do to adhere to the order and still do our jobs. Lots of guessing occurs. Some errors may come with it. It is in this type of environment unintentional spoliation can easily occur and the results can be devastating for our company. In the digital Internet of Things era, the best way to protect our organization from the risk of spoliation is to have a computer forensics investigator assist in preserving our electronic data and letting our employees get back to work. This expert will literally make an exact duplicate copy of our data that can be used in the court proceedings. Computer forensics can be performed in a very short amount of time, will have no impact on our computer systems, and will leave nothing to chance in terms of spoliation. In most states, computer forensics must be performed by an internal employee trained in proper evidence collection practices and equipped with court-recognized computer forensics software. Monet Bank does not have an internal department that provides this type of evidence collections. We will have to look outside the organization to a private investigator trained to perform the computer forensics evidence collection. Our forensics experts should be licensed practitioners who help ensure no digital evidence is overlooked and assist at any stage of a digital forensics investigation or litigation, regardless of the number of location of data sources. Cyber insurance is an extended business liability coverage that protects against cybersecurity risk involving technology systems and customer data. As businesses move into the digital space, cybercrime is becoming more common, making it challenging for business owners to protect themselves from cyber attacks. If hackers or cybercriminals infiltrate a business network, take over their website, hold data hostage, or steal sensitive client information, the businesses can be held liable for the incident besides having to take care of the recovery costs. In case of a litigation against Monet Bank, to be successful in a defense of due diligence, we must show we have taken all the precautions that a reasonable and prudent person or organization would take under the same circumstances. Having an intelligent cybersecurity compliance program will help us demonstrate due care. In cybersecurity tort law, the duty of care doctrine is a legal obligation which is imposed on an individual or company to adhere to a standard of reasonable care while entrusted with safeguarding personal or confidential information. Monet Bank has a duty of monitoring its cybersecurity controls necessary to secure the bank and demonstrate that we do everything to prevent cyber attacks. And now a few important summary notes for Monet Bank compliance management framework to be effective. Certain elements are necessary. Compliance program. For Monet Bank to comply with all rules and regulations sets, there must be a compliance program to follow. Commitment from the Board of Directors. The board of directors in an organization acts as the management oversight in every aspect of the organization. Monet Bank's senior management should be committed to integrity, and that Monet Bank Incorporated will abide by the laws. Being at the top, they must lead by example for other junior employees to learn from them. The board of directors should come up with a code of conduct, communicate the expectations, adopt policies, and explain to the Monet Bank staff the proper compliance function. They should use proper enforcement programs to ensure that everyone in the company observes the compliance guidelines. The board of directors and management oversight should provide the necessary resources that will allow laws and regulations to be applied at Monet Bank. Consumer Compliant Program. For our compliance management framework to be successful, it is essential to know the feedback from our data consumers. An audit from an independent body. A compliance audit is a review of an organization's compliance with the laws and regulations. It also reviews whether there is adherence to the internal policies and implementations. At Monet Bank, a compliance review should be carried out by an independent body to avoid bias reviews. We must conduct compliance audits regularly. The senior management should come up with the scope of the audit and provide the independent body with all the materials and resources required for the audit. Once the audit is completed, the reports must be documented, gaps identified for Monet Bank to come up with corrective actions. The audit report should be handed over to the top management or the board of directors for further action. Compliance Risk Assessment Framework. A compliance risk assessment framework helps organizations identify, assess, and manage compliance risk. Monet Bank framework should be tailored to our organization's specific business activities, internal controls, and compliance requirements. This will help us identify gaps and weaknesses in the controls that could lead to compliance risk. The next step will be to conduct an audit of the compliance function. This will assess whether the compliance function is adequate and effective in managing compliance risk. Finally, we must develop a plan to mitigate any identified risk. The plan should address how Monet Bank will implement new or revised internal controls and compliance procedures. By following these steps, Monet Bank can develop an effective compliance risk assessment framework and will help us identify, assess, and manage compliance risks. You probably are wondering what is the best compliance framework that Monet Bank can adopt. Now, there is no one-size-fits-all answer to this question, as the best compliance framework will vary depending on the specific needs of the bank. However, some of the most common compliance frameworks used in the banking industry include ISO 27001, NIST 853, and PCI DSS. Though it may seem like a lot of work implementing a legal and regulatory compliance management framework, it will bring in a lot of benefits for Monet Bank. We will not have to worry about being on the wrong side of the law, have a stable financial department, build a good reputation, and identify the right suppliers. Therefore, as the Chief Legal and Privacy Officer at Monet Bank, I behoove you, the senior management, to implement a compliance management framework or system immediately and start enjoying the results. I thank you once again for attending today's presentation. I hope it was informative for you as well as enjoyable. So until next time, stay safe, take care. Goodbye.